Welcome to the Overdose Enigma. We will explore global fentanyl overdose patterns, uncover suspicious data gaps, and address the questions governments avoid. Over 190,000 people die annually from drug overdoses, mainly opioids. In 2017, the top 20 countries with the highest overdose rates shared a notable demographic pattern. Interestingly, Mexico and China, often cited as major manufacturers, are absent from this list. This raises questions about the official narratives regarding the crisis's origins and impacts. The 2017 overdose data highlights a geographic concentration of fentanyl overdoses in Northern and Eastern Europe and North America. These regions share a notable demographic trait, predominantly light-colored eyes. This correlation raises questions about underlying factors contributing to the crisis. This is a map detailing the rates of overdose per million, with the darkest color being the highest number of deaths from overdose. Below it is the eye color map of the same region. As you can see, the highest rate of deaths from overdose only happens where 90% of the population has blue eyes. These rates account for the world, not just Europe alone. Links to these maps are in the description. Researchers have noted a striking correlation between eye color distribution and drug overdose mortality. Northern European countries with high blue-green eye rates show high overdose mortality. In contrast, Mediterranean nations with predominantly brown eyes have lower overdose rates. Sub-Saharan Africa and Southeast Asia with near-zero blue eyes experience minimal fentanyl overdose crises. Estonia, with a population of just 1.5 million, ranks second only to the United States in fentanyl overdose rates per capita. Notably, over 99% of Estonians have blue eyes. This unusual correlation between eye color and overdose rates challenges statistical norms, prompting further investigation into potential underlying factors. Portugal's low overdose rates are often attributed to its drug decriminalization policy. However, investigative communities suggest a biological factor, noting Portugal's high proportion of brown-eyed people. Interestingly, Spain, Italy, and Greece, also with high brown-eye populations, report similar low overdose rates despite differing drug policies. Could this indicate an overlooked biological pattern? The United States government claims illicit fentanyl is manufactured in China and Mexico, trafficked by cartels across United States borders, and sold on United States streets, causing mass overdoses. This narrative, supported by the Drug Enforcement Administration and Centers for Disease Control and Prevention since 2017, raises questions. Why don't Mexico and China experience similar overdose death rates? There's an unexplained gap in this official story. The conspiracy research community questions the randomness of fentanyl distribution, suggesting it may be deliberate. Who benefits? Pharmaceutical lobbying, private prisons, and patent holders profit significantly. Overdose data suggests targeted distribution, not chaos. Notably, no major study has explored the correlation between eye color demographics and overdose mortality. Why is academia silent? The biological hypothesis suggests eye color, determined by melanin, might influence pain sensitivity and opioid receptor interaction. Studies indicate lighter-eyed individuals may have different pain thresholds, potentially making them more susceptible to fentanyl. This isn't necessarily a conspiracy, but could be a biochemical reality overlooked by health authorities. Governments have a history of targeting populations during health crises. The Tuskegee experiment withheld syphilis treatment from Black men. MKUltra involved Central Intelligence Agency drug experiments on citizens. Operation Sea Spray saw biological agents sprayed over San Francisco. The opioid rollout targeted specific regions with opioids, proven in court. These precedents warrant serious consideration. Transparency requires publishing supply audits and declassifying Drug Enforcement Administration tracking. Independent fentanyl studies and releasing raw demographics are crucial. Without detailed demographic data, including biological markers, patterns remain unconfirmed, fueling suspicion. The correlation between eye color and overdose rates requires independent scrutiny. Why do source countries like Mexico and China not suffer similar rates? Estonia's status as a global epicenter, despite its small population, demands investigation. The lack of academic study on demographic overlaps is concerning. Transparency is crucial. Question everything.
Welcome to Fighting for Your Child, your Section 1983 federal civil rights case. This guide empowers you through every crucial step after filing your Section 1983 claim in federal district court. Federal courts welcome pro se litigants, understanding you are not an attorney. Section 1983 empowers you to hold government actors accountable for constitutional violations. Your efforts seek justice and compensation for your child. Remember, you are a capable advocate, and the law supports you when your rights are violated. Section 1983 exists precisely to hold government actors accountable. A social worker or officer who violated your constitutional rights can be sued, and you have standing to do it. The Federal Rules of Civil Procedure, FRCP, are essential for every federal lawsuit, dictating case progression and document requirements. Access them free at uscourts.gov. Remember, local rules are equally binding and specific to each district court. When rules conflict, adhere to both and consult the clerk's office for guidance. In federal court, deadlines are crucial. Missing one can end your case. Pro se litigants receive no automatic extensions. Calendar dates immediately. Count days per Federal Rules of Civil Procedure Rule 6 and file early. Technical issues aren't excuses. Request extensions formally if needed. Missing deadlines can lead to default judgment, dismissal, or waiver of rights. Calendar every date the moment you receive a notice or order from the court. Count days carefully. FRCP Rule 6 explains how to count deadlines, including weekends and holidays. File early, never the night before. Technical problems with the court's e-filing system are not an excuse. Request extensions in advance using a formal motion if you truly need more time. Never just miss the date. After filing your complaint, expect a scheduling order under Federal Rules of Civil Procedure Rule 16. This crucial document outlines all major deadlines, including discovery cutoff and trial date. Read it immediately and calendar each date to ensure compliance and effective case management. If you've named John Doe defendants, act quickly. File a motion for early discovery to identify them. Explain the necessity as only the government holds their records. Once identified, amend your complaint under Federal Rules of Civil Procedure Rule 15 to substitute the real name before the statute of limitations expires. Before the official discovery period opens, file a motion asking the court for permission to conduct early, limited discovery specifically to identify the John Doe defendants by name. Your motion must explain that you cannot serve a defendant or proceed without knowing their identity, and that only the government employer, the city or agency, holds those records. Once you learn the real name, promptly file an amended complaint under FRCP Rule 15, substituting the real name for John Doe before any statute of limitations expires. Request oral argument when legal issues are complex, or if a judge might better understand your position by hearing you. Skip it if your brief is clear, or if it might reveal knowledge gaps. File a motion for oral argument per local rules. If granted, prepare a concise 3-minute summary. When defendants file their answer, read it carefully to note all defenses, especially affirmative ones like qualified immunity. Check for counterclaims, as you must reply within 21 days under Federal Rules of Civil Procedure Rule 12A. Use their answer to update your strategy, refining discovery requests and anticipating summary judgment arguments. Government defendants often file a motion to dismiss under Federal Rules of Civil Procedure Rule 12B6, claiming your complaint fails to state a claim. File an opposition within 21 days, restating your factual allegations, citing Ashcroft v. Iqbal and Bell Atlantic v. Twombly, and addressing qualified immunity arguments directly. Confirm deadlines with local rules. If your case is dismissed, consider filing a Rule 59E motion within 28 days to address legal errors or overlooked facts. For extraordinary circumstances, use Rule 60B without a strict deadline. If dismissed without prejudice, you can file an amended complaint under Federal Rules of Civil Procedure Rule 15. Dismissal is not the end. It's a chance to strengthen your case. It is an invitation to come back stronger. Many successful civil rights cases were dismissed and refiled. Discovery is crucial in building your case. It compels the government to disclose hidden evidence, like emails and reports. Use interrogatories to question policies and decisions. Request specific documents under Federal Rules of Civil Procedure, Rule 34. Seek admissions under Federal Rules of Civil Procedure, Rule 36. These admissions are binding and impactful at trial. Responding to discovery requests is crucial. You must answer defendants' interrogatories and document requests truthfully within 30 days under Federal Rules of Civil Procedure. Failure to comply can lead to sanctions or case dismissal. Produce records, photos, texts, medical or counseling records, and your written account of events. If you lose at the district court, you can appeal to the United States Court of Appeals. Mark the final judgment date immediately. File a notice of appeal within 30 days, or request an extension for up to 60 days if needed. After docketing, follow the circuit court's briefing schedule closely. A loss at the district court level is not the end of your fight. The U.S. Court of Appeals for your circuit reviews whether the district court applied the law correctly. Appeal briefs must focus on legal errors, not new facts. Follow the Federal Rules of Appellate Procedure and your circuit's local rules for formatting. Use the district court record and file an appendix with key documents. Many circuits offer pro se help desks. Contact your circuit's clerk office for available resources. District court rules vary significantly. Page limits, font, and filing formats differ by location. Always check your district's official website for local rules and standing orders. Clerks can confirm formatting compliance. Utilize pro se clinics and legal aid programs for filing assistance. Page limits, font requirements, filing formats, and motion procedures vary by district. What works in the Southern District of New York may not be accepted in the Northern District of Texas. Clerks cannot give legal advice, but they can tell you whether your document meets the court's formatting requirements and point you to the correct forms. Use this free resource. After filing your Section 1983 complaint, ensure proper service under Federal Rules of Civil Procedure Rule 4. Read and calendar deadlines from the scheduling order. Complete Rule 26A disclosures timely. As the case progresses, respond to motions and discovery promptly. Consider oral arguments and file appeals within 30 days if needed. Utilize pro se resources for guidance. The law equips you with tools, and your love for your child fuels your courage. Stay organized by keeping all documents in one place. Persistence is key. Meeting every deadline proves your determination. Confidence in your case knowledge is powerful. Trust yourself and continue the fight for your child. You know the facts of your case better than any lawyer. That knowledge is powerful. Your child is counting on you. Welcome to our discussion on Justice Denied, the Blake Decision, and Washington's Forgotten Parents. We'll explore how a 2021 ruling revealed unconstitutional family separations and the urgent need for action by the Washington State Supreme Court. In February 2021, the Washington State Supreme Court ruled in State v. Blake that the state's simple drug possession law was unconstitutional. This law allowed convictions without knowledge of possession, violating due process protections under state and federal constitutions. The Blake decision's retroactive application invalidated thousands of drug possession convictions dating back to the 1970s. Courts vacated charges and cleared records across Washington. Tens of thousands of cases were wiped from the record. However, Washington swiftly enacted temporary legislation to re-establish drug possession laws. Retroactive relief applied from the 1970s through 2021. While the Blake ruling swept away criminal records, it completely ignored the devastating collateral consequences suffered by thousands of Washington families. Parents who lost their children, not because of a crime, but because of a law later ruled unconstitutional, were left with no remedy, no apology, and no path forward. The courts corrected the criminal record. They never corrected the broken families. For over 2 decades, Washington parents faced family separations due to unconstitutional laws. These separations were based on positive drug screens and incomplete treatment programs, despite the law's lack of constitutional validity. Parents across Washington were removed from their children's lives based on dirty drug screens and failure to complete treatment programs, all tied to a law that was never constitutional to begin with. Parents faced a systematic process where positive drug screens led to Child Protective Services removal, mistreatments, and ultimately the loss of parental rights. Despite no criminal charges, drug use was the primary basis for these severe actions, permanently severing family ties. Under the unconstitutional law, simple possession was a strict liability felony, requiring no criminal intent. Dependency courts used positive drug screens and treatment non-compliance to remove children, place them in foster care, and terminate parental rights. Parents were never convicted, yet families were permanently separated. These parents were never convicted of a crime. The law underlying every one of these actions was unconstitutional. Yet the state permanently separated families as if it were justified. Parents were compelled to pay child support for children they were unconstitutionally separated from. Despite the removal, the state enforced these obligations, leading to payments amounting to thousands over decades. This financial burden was unjust, and restitution is necessary. Parents' fundamental rights were violated under the 14th Amendment. Their right to care, custody, and control of their children was removed without due process. They faced penalties in civil court for actions not legally criminal under Blake. The state's actions lacked constitutional grounding, undermining family integrity. Parents were penalized in civil family court for conduct that, under Blake, was never legally a crime. They were treated as criminals without a criminal conviction. Parents have a fundamental constitutional right to the care, custody, and control of their children. Removing that right based on an unconstitutional law is a due process violation. The Washington State Supreme Court must formally acknowledge the harm caused by unconstitutional family separations linked to Blake-era drug possession findings. They should mandate child support reimbursement, create a compensation framework for affected parents, and review all cases impacted by these unconstitutional laws. Issue a formal ruling acknowledging that family separations tied to Blake-era drug possession findings were based on unconstitutional grounds. Establish a process to identify and repay all child support collected from parents whose children were removed under unconstitutional drug law enforcement. Develop a reparative process that compensates parents for unconstitutional separation from their children, including lost time, emotional harm, and financial losses. Mandate a statewide review of dependency and termination of parental rights cases where substance abuse findings under the unconstitutional law played a central role. This issue extends beyond individual families. It's a systemic injustice affecting thousands across Washington. Dependency courts statewide operated under unconstitutional frameworks, impacting many low-income and vulnerable parents. Silence from the court perpetuates this injustice, highlighting the urgent need for corrective action. The Blake decision was a courageous step by Washington's highest court, but it requires action. Parents affected by this unconstitutional framework deserve justice. The law's consequences must be reviewed. Speak up to legislators, seek legal help, and connect with advocacy groups to fight for family justice. Welcome to our guide on filing a disability discrimination lawsuit pro se. This presentation will provide a step-by-step approach for individuals representing themselves in federal and state court. Understand your rights, remedies, and the legal roadmap ahead. The Americans with Disabilities Act protects against discrimination in employment, public services, and accommodations. Title I applies to employers with 15 or more employees. Title II covers state and local government programs, while Title III addresses public accommodations. The Rehabilitation Act, Section 504, applies to federally funded programs. Check state laws for potentially broader protections. Valid reasons to sue include employment claims like wrongful termination, failure to provide reasonable accommodation, discriminatory hiring, hostile work environment, and retaliation. Public life claims involve denied access to buildings, lack of accessible facilities, refusal of service, inaccessible digital services, and exclusion from public programs. You can sue employers with 15 or more employees under Americans with Disabilities Act, Title I. State and local governments fall under Americans with Disabilities Act, Title II. Businesses open to the public, like restaurants and hotels, are covered by Americans with Disabilities Act, Title III. Private individuals are generally not suable under the Americans with Disabilities Act. For employment discrimination claims, filing an Equal Employment Opportunity Commission charge is mandatory before suing in federal court. You must file within 180 days of the act, or 300 days if your state has an anti-discrimination agency. After receiving your right to sue letter, you have 90 days to file in court. Do not give up on your EEOC claim, because we have met real people that have gotten a lot of money, like more than $20,000, from just filing a claim with EEOC. They never had to go to court or anything. It took 4 years, but it still happened. You might think they are a small agency, but they do big things for people. For employment discrimination, failure to accommodate, or workplace retaliation under Americans with Disabilities Act Title I, file with the Equal Employment Opportunity Commission first. It's free at eeoc.gov or local offices. For Americans with Disabilities Act Title II, Title III, or Section 504 claims, you can go directly to court. But consider filing with the Department of Justice or Department of Health and Human Services to strengthen your case. Choose the right court for your case. File Americans with Disabilities Act and Rehabilitation Act Section 504 claims in federal district court where the discrimination occurred. Use state court for state civil rights violations, or if your employer has fewer than 15 employees. Small claims court is generally unsuitable for Americans with Disabilities Act cases due to their complexity. To prepare your federal civil complaint, include a caption with your name, the defendant's name, court name, and case number. Explain jurisdiction under the Americans with Disabilities Act, 42 United States Code, Section 1201. Provide a chronological statement of facts detailing the discrimination. Clearly state legal claims and desired relief, such as damages or attorney fees. To file a lawsuit, you'll need several forms. The civil complaint initiates your case. The civil cover sheet categorizes it. A summons notifies the defendant. If you can't afford fees, submit an in forma pauperis application. For Americans with Disabilities Act claims, file an Equal Employment Opportunity Commission charge first and obtain a right to sue letter. Check local court rules for additional forms. Filing a civil case in United States District Court costs $405, but Equal Employment Opportunity Commission charges are free. If you qualify for an in forma pauperis waiver, the filing fee is waived. Additional costs include process servers, copies, and expert witnesses. Winning an Americans with Disabilities Act case may result in the defendant covering your attorney's fees and costs. After filing, you must serve the lawsuit to the defendant. Federal courts require proper service under Rule 4 of the Federal Rules of Civil Procedure. Anyone not a party to the case and at least 18 can serve. Deliver a copy of the complaint and signed summons. File a return of service form within 90 days. You can recover compensatory damages for real losses like lost wages and medical costs. Punitive damages punish intentional discrimination. Injunctive relief may require the defendant to stop discriminatory practices. If you win, the Americans with Disabilities Act allows recovery of attorney's fees, even for pro se litigants in some circuits. In federal court, you must prove discrimination by a preponderance of the evidence. Document everything: emails, denials, medical records, witness names, and dates. Qualifying disabilities include physical impairments, mental health conditions, and chronic illnesses. A comprehensive paper trail is crucial for your case. Understand critical deadlines. File an Equal Employment Opportunity Commission charge within 180 days, or 300 days if your state has its own agency. After receiving the right to sue letter, file your federal lawsuit within 90 days. Serve the defendant within 90 days of filing. Americans with Disabilities Act Title II and III claims have a 2 to 4 year statute of limitations. Missing deadlines can end your case. Explore free resources for pro se litigants, Equal Employment Opportunity Commission's website for filing employment charges, and Americans with Disabilities Act guidance. Americans with Disabilities Act National Network's hotline for rights clarification, court pro se clinics for legal assistance, and legal aid organizations like Disability Rights Advocates for potential free representation. Avoid common pitfalls in pro se filings. File your Equal Employment Opportunity Commission charge within 180 to 300 days to prevent dismissal. Ensure you sue the correct party, typically the employer, not an individual. Be specific in your complaint with detailed facts. Lastly, don't skip the service of process. Serve the defendant within 90 days. Filing pro se for disability discrimination is challenging but achievable. Start by gathering evidence and filing your Equal Employment Opportunity Commission charge. Prepare your complaint, civil cover sheet, and summons for court submission. Seek support from pro se clinics, legal aid, and the Americans with Disabilities Act National Network hotline. Remember, this is informational. Consult a disability rights attorney for legal advice.